Доброго дня, шановні учасники вебінару.
Dear colleagues and friends, participants of this webinar, relevant aspects of construction procurement in Ukraine and EU member states. Welcome to our webinar. And now we're about to start our work. This webinar is organized with the support of Ministry of Economy, Environment and Agriculture, Department of Public Procurement, and with the support of EU program to support Public Finance Administration in Ukraine, EU4PFM. Today we will talk about Lithuanian experience of construction work pricing, novelties in new law of public procurement, and specific features of procurements based on design and build project. Today we're about to have our guests, our international guests, Ukrainian experts from the Ministry of Economy, Environment and Agriculture and EU4PFM project. Please stay with us and wish you fruitful work. But before we start our webinar, I would like to discuss with you several housekeeping issues that will help you to proactively participate in our event. This webinar will be broadcasted on Facebook page of our project, EU4PFM, and also on our YouTube channel in English and in Ukrainian. In the left corner, on the top left corner, you can find the QR code to download our agenda and presentations. So we're about to start, and now we kindly invite Mr. Eric Smizalis for his welcoming remarks, Head of Relevant Component at EU4PFM project. Mr. Eric, please, the floor is yours.
Good morning, dear ladies and gentlemen, friends and colleagues. My name is Eric Smizalis, and I am the team leader of the Component 2 Public Procurement within the EU4PFM program. Launched in January 2024, our component focuses on assisting Ukrainian partner institutions in implementing reforms in public procurement area. As we all know, Ukraine is on its way to join the European Union, and therefore Ukraine is undertaking sweeping reforms in many areas, including public procurement. Implementation of the EU procurement directives and purchasing approaches will contribute to the efficient public procurement market in Ukraine and optimal allocation of taxpayers' money. However, when we speak about the reforms, we are not speaking only about the legislation alignment. Although this is also very important, we are speaking also about the practical implementation. And when we speak about practical implementation, that relates both to the provisions of the new public procurement law that we are all expecting to be adopted, as well as to the current legislation. Construction procurement is arguably one of the most complicated procurement types, certainly most financially demanding. And in Ukraine's public space, like in other countries, it is often debated. Appraisal of estimated value, use of FIDIC contracts, choice of the most suitable tender procedure, choice of the contract type, contract amendments, these are the questions very, very frequently discussed. And there is, of course, also a discussion on the transparent prices of the construction materials. Probably we all have heard about these discussions or maybe even participated in them. And to contribute to this discussion, we and our partners decided to organize this workshop. Of course, this is a 2.5-hour-long workshop. It might not provide all the answers. However, it may provide at least part of them, and it could also show us the working directions to arrive to some practical solutions. So, without further ado, I would like to thank the colleagues from the Ministry of Economy, Environment and Agriculture of Ukraine, from the Central Project Management Agency of Lithuania, as well as from the Procurement Component project team for their contributions, for the preparation of the workshop, and for the presentations that they will deliver today. I would like to wish you a successful and very, very useful and practical workshop. And please let us stay in the discussion about the construction procurement, about other procurement-related things also in the future. So thank you a lot again. And dear Luda, over to you.
Дякуємо, пане Еріксу.
Thank you so much, Mr. Eriks. And now I kindly invite Vitaly Shergin for his welcoming remark. As Director of Public Procurement Department at the Ministry of Economy, Environment and Agriculture. Mr. Valery, please, the floor is yours. Good morning, dear friends. Good morning, colleagues. Hello, everyone. I'm happy to welcome you at this workshop. I'm sincerely grateful to EU4PFM International Technical Assistance Project for organizing this important workshop and for supporting the Public Procurement Department on a path towards alignment of Ukrainian legislation with EU directives, saying which Eriks kindly mentioned. And I sincerely share your optimism and ambition and believe that very soon Ukraine will become a full member of the European Union. And yes, indeed, I absolutely agree with you, Mr. Eriks, that public procurement of construction works are probably one of the most challenging, complicated, and financially demanding, but at the same time, the most interesting area of public procurement. Because there's always need to buy works to build something, it has become an essential driver to introduce amendments to the construction legislation like it happened in Europe and like it's about to happen in Ukraine. I hope that in the next few months we will see updated law of Ukraine on public procurement. And during the last few months, we have worked on improvement of this draft law. And we have also discussed several issues related to implementation of procurement procedures provided by EU directives. And one of the reasons why it's necessary to implement all directives, all these procurement procedures, is the fact that almost each and every of them can be used for procurement of works. And then, depending on the project, depending on whether this project is already developed, or whether it's design and build project procurements, when we have just an idea, just a concept of building something, but the community or specific client is not sure whether they properly know what to buy. Well, in this case, European directives and updated law on public procurement and fully updated and revised procurement legislation will define the procurement solutions to be used. Another important point I want to highlight. As Mr. Eriks mentioned, EU directives, EU procurement directives are more focused on contracting process. It's more about contracts. So, amending essential contract provisions is a very big issue. Sometimes it's a problem, sometimes it's a challenge, but it's still always very interesting, very responsible part. And I'm really happy that the part of our workshop will focus on this part specifically. My colleague Mikhailo Mokhnia will introduce some novelties related to procurement of construction works, which hopefully will be implemented as part of the new draft law. And I wish you fruitful and exciting webinar. Please stay with us, ask your questions, and we will do our best to answer some of them at the end of the webinar. And you all perfectly know that the Public Procurement Department has its own webpage on the Ministry of Economy's website, so please feel free to share your questions and feedback there as well. Wish you a productive seminar and thanks. Thank you, Mr. Eriks, for these welcoming remarks, and we hope that our work will be fruitful and inspiring. So let us start. First, I would like to kindly give floor to Ms. Inga from Lithuania, who will present a report on Lithuanian practice of assessment of expected value of procurements and the rules. We will kindly introduce Ms. Inga. She has significant experience, over 19 years, including 15 years in CPMA, Central Project Management Agency. Ms. Inga expertise covers the monitoring of legislative compliance, investigation of violations during procurements, including construction of educational establishments in Ukraine. Her professional experience includes positions and work at Lithuanian Railway, Consortium of Scientific Libraries, District Heating Company, and Supreme Administrative Court of Lithuania. Recently, Ms. Inga joined the typical construction contract for Lithuanian public procurement contractors, clients and recommendations for engineering supervision for Agency of Recovery and Development Infrastructure of Ukraine. Also, she participated in designing future schools for Ukraine as supported by the President of the European Commission, and she received the award as smartest procurement in Lithuania. I'm happy that Ms. Inga joined us, and she will introduce Lithuanian practice. This particular issue was found in registration form, and we will receive more detailed information.
Good morning.
Thank you. Good morning.
In construction procurement, we often face very similar challenges, and I will share Lithuanian practice, which is based on European Union principles, directives, and case law. This might help you when designing or revising your own national rules and practices. In this slide, you will see photos from our agency's construction sites in Ukraine. They were taken during our in-site visits while the works were in progress. We procure construction works in accordance with the Lithuanian law on public procurement, but we apply Ukrainian construction laws at the contract execution stage. Well, and I today will share Lithuanian practice on two very much related topics in the works procurement. First, how to determine the estimate value of construction works contracts and where it is used. And secondly, how we address contract value modifications, in particular, how we price omitted works and additional works during contract performance. In Lithuania, we have a single methodology for calculating the estimated value of public procurement. Estimated value must cover all procurements to the supplier over the entire term of the contract, and all options and possible extensions must be included. Any additional payments and options must be included as not to artificially lower the estimated value. For example, we as CPLA introduced bonuses in some works contracts in Ukraine. To get a bonus, at least 10% of the staff employed under the contract must be verified war veterans. The contractor might receive a bonus equal to 1% of the contract value for war veteran employment. And these bonuses must and are included in the estimated value of the procurement. The estimated value of works is aggregate value of all contract for works, which together as a result of construction and engineering activities perform one economic or technical function. Where works and engineering activities are implemented under a single technical project or single technical specification, they are deemed to constitute one construction object. There might be no need to have a technical project. Then in this case, identical or similar construction works are treated as a single object and are aggregated. We have an official list from European Public Procurement Directive where it is listed. When we talk about the estimated value of works procurement, we do not mean only the construction works. We also have to include several related elements. If the design is procured together with the works in one design and build contract or similar contract, the full value of the design services are included. Also, supplementary services included. These are services like construction site security, removal of construction waste, and also customer supplied materials, equipment, or components need to be included in the estimated value of the work. And there is one important exception. Technical project expertise services are procured separately from works contract, because it is required under Lithuanian construction regulation, and those costs are not added into the value of the work contract. Calculating the estimated value is essential for choosing the appropriate procurement procedure. The current European Union threshold for works contracts is €5,538,000, and it is changed each 2 years. And it means that a threshold marks the point at which European directive must be applied. Below this level, Lithuania may use its simplified procurement regime. For low value works contracts, we have a lighter national regime. At the planning stage, the needs and the budget are clarified. They are based on available information and historical data from similar projects. Then we usually publish a market consultation. This helps us to see the current price level and whether the market understands our draft technical requirements. If market prices turn out to be different than expected, or if we refine the specifications after suppliers' feedback, we adjust the budget. We do this before starting the procurement procedure. And when necessary, we also update the annual procurement plan. For example, just yesterday, we met to adjust the estimated contract value for one of our procurements in Ukraine. After market consultation, we had received indicative prices and other insights from our potential suppliers, which showed us that our initial estimate needed to be updated. Well, but still, we face a key question on how to determine a realistic price for construction works. In Lithuania, economical calculations can be done in several ways. By comparing prices from similar or analogous projects, by using norms or methodologies prepared by academic or research institutions, by using the recommendations on the determination of calculated prices, or by any other method as long as it is well justified. For this case, we have methodology for establishing pricing rules, and you may see the link here in this slide. In Lithuania, we also use centrally registered recommendations for estimated construction prices. They are managed by the public institution, Construction Sector Development Agency, and these recommendations might be prepared by different organizations, companies, academic institutions, but specific prices are with the authors of the recommendations. And for now, we have one leading company having special software for this recommendation. And the list of registered recommendation is publicly available on the agency site. So when we need to estimate construction costs, we often refer to these registered recommendations as one of our key sources. And usually, the estimated prices of construction resources are updated twice a year. And here in the slide, you can see the most recent recommendations for determining the estimated construction costs of structures. For example, calculated market prices of construction resources are based on October 2025 market prices. This autumn's market prices. And it includes calculated market prices of construction materials and products for the operation of construction machines and mechanism, market prices of one labor hour, and general economic norms for the calculated prices. The authors of recommendations must follow the principles for determining the estimated construction cost. This ensures that all recommendations are prepared on a consistent and transparent methodological basis, and it is easy to find. And this, here you can see the table that shows the main cost components. Main cost components are direct costs and indirect costs, and direct costs consist of construction works cost and site costs. Construction works costs consist of construction products and equipment, operational and rental of machinery, workers' wages, and social insurance of their wages. While the construction site costs consists of construction products and equipment used for setting up and operating the construction site, and costs of installing and operating machinery on site, wages of site staff, and social insurances of their wages. And indirect costs consist of overheads and profit and risk. Overheads share of general material costs for running the organization as whole, and for operating taxes. And share of general transport costs, share of wages, and social insurances. And profit and risk as well. So the table provides a standard structure for compiling all costs of a construction project, from direct work and site costs to overheads, profit, risk, and taxes. Here we have part of a summary calculation of the construction costs, which comprises of construction site, preparation of the construction site, construction and installation, design and engineering services, other costs, and reserve. Public buyers also must include a reserve for unforeseen costs in the internal construction cost estimate. This reserve must be used for unexpected expenses and is not shown in the tender documents or in the contract. It means that contractor should not know the amount of the reserve. And typical reserve levels are up to 5% when construction lasts up to 1 year, 10% up to 10% if it lasts more than 1 year, and for repair and reconstruction project, and up to 15% when the price is based on a raw aggregated indicators or expert estimates. And this, of course, reserve might be needed for contract modifications. Contract modifications are almost inevitable in construction contracts. It's almost impossible to complete project without any contract modifications at all. The question is not whether we will amend the contract, but how we do it so that changes remain lawful. Public procurement contracts may be changed during their term if certain legal conditions are met. The key principle is that amendments must not be used to bypass public procurement rules or distort competition. If a change is essential, then a new procurement procedure is required. And here you can see 6 main possibilities to modify the contract. Lithuanian law reflects all options that are allowed under the European Union Public Procurement Directive. Most of them are related with monetary changes. And in construction, we use only these 6 possibilities for amendments. The first one is foreseen modifications. These are changes that are clearly described in the original procurement documents. For example, it might be review clauses, the price indexation formulas, options for additional quantities, or technically justified design adjustments. If the clause is clear and transparent, we can use it without a new procurement procedure. But the standard of clarity is high. Vague or general references to potential changes are insufficient. This requirement ensures that all potential bidders were aware of the scope of modifications at the time of tendering. Well, in 2022, we faced a huge increase in prices, and many construction contracts in Lithuania became problematic because they didn't allow any price adjustments. So it became necessary to introduce mandatory price review clauses. Since that year, it is mandatory to include a contract price review clause where the duration of works exceeds 6 months. We also have standard price review clauses, which were incorporated into the standard contract for construction works, which were developed last year. A mandatory version of the standard contract is expected to be introduced soon. Here you can see the standard price review clause. The amounts payable to the contractor for the construction works are recalculated if the official price index changes. We use the data published monthly by the Lithuanian State Data Agency. Recalculation is applied when the value of the building repair cost element price index changes by more than 5%. And in other cases, the same principle applies, but the construction cost element price index that best corresponds to the type of object changes is used. When this happens, the contract price is recalculated only for the part of the works not yet performed. And here you can see also the formula. As a standard, the first review of the contract price might be carried out not earlier than 6 months after the contract enters into force. After that, the contract price might be reviewed no more than once every 6 months. But of course, it is possible to change limits before procurement procedure if there is a high possibility that prices of construction cost elements may change significantly within a short period of time. But also, it might happen, and it happened before, that prices increase very sharply. The contractor could not foresee this when signing the contract. In such a case, the contractor may ask the customer to increase the contract price. And this is allowed if the contractor proves 2 elements. The original prices were realistic and the increase is significant. That means more than 15%. And the prices in the details price schedule where the condition is that the prices in the detailed price schedule were in line with the market and they were not artificially low. And most suppliers had offered similar prices. They had offered similar prices. Also, the increase must be significant. It means that either the price of a specific product or the total price of all products have increased by more than 50%. And it also must be impossible to buy cheaper without delaying the work. And the same logic applies when the prices decrease. Then the contract price should be reduced. It also might be necessary to buy additional works, services, or supplies from the same supplier that were not included in the original contract. This is also allowed, but only in strict cases. There must be 3 conditions met. First one, change of supply is impossible or very difficult due to economic or technical reasons. For example, to ensure interchangeability with the equipment, and changing the supplier would cause major inconvenience to the public buyer, or may lead to significant duplication of costs. Secondly, the value of each modification doesn't exceed 50% of the original contract value. And of course, these modifications cannot be used to avoid mandatory procurement rules. Well, still, sometimes we need to change a contract because something happens that a diligent public buyer could not reasonably foresee. For example, unexpected ground conditions or new mandatory requirements. In such cases, a modification can be made without a new tender, also under 3 conditions. The change doesn't alter the nature of the contract. It means that the object remains the same. We're not turning one type of project into another. The value of each such modification is below 50% of the original contract value, and the change is not used to avoid applying procurement rules. So this is a gateway. So this is a gateway that gives some flexibility for truly unforeseen situations. Well, in any case, circumstances that already existed when the tender was launched cannot be treated, when the procurement was launched, cannot be treated as unforeseeable, and they cannot justify this type of contract modification. Also, here is a possibility to modify a contract, but it's not related to any monetary changes. I included it here just for your information that it's also possible. There is a possibility for non-essential modifications of contract. In any case, it means that the overall nature of the procurement contract must not be changed. For example, it is not allowed from stadium renovation, modify contract to roof renovation. And that means it is that it is not an adjustment of quantities or a small change of scope, and it's a change of the core subject of the contract and is not allowed. And public procurer must carry out a new procurement procedure. There are four main conditions for contract not to be modified, and it is called substantial modification. In a case a new condition is added to the original tender, more suppliers might have been interested in original procurement. That is not allowed. The modification changes the economic balance of the contract in favor of the contract, and is also not allowed. And as I already mentioned, modification significantly increases the scope of contract, and the original contract is replaced by the other in other ways than allowed by the law. For works contracts, we also have a rule for small changes. A works contract may be modified without a new procurement procedure when there are three conditions met. The first one is that total value of such small modification doesn't exceed the EU threshold. The total value is not more than 15% of the original contract price, and the modification doesn't change the nature of the contract. And this was the last option for modifying the contract. And in this slide, we see the ways quantitative changes might occur, and their value must always be calculated and checked. Quantitative modifications means that the contract object is changed because of cancellation of part of the works, goods, or services, reduction of their quantity, replacement, purchase of additional, and increase of their quantity or scope. When we change quantities under works contract, we are not free to invent new prices. It's obvious. If the contract doesn't set another rule, the public buyer must use methods which are strictly described, and they are strict in priority order. First of all, we use unit rates from the contractor's tender. Secondly, we derive a partial rate from an existing priced item in the contract. Thirdly, we apply unit rates for similar works or services that are already in the contracts. And only then we apply a new rate from justified direct costs and indirect costs according to the recommendations I mentioned earlier. I will explain this method in detail in the following slides. If the contract has no suitable unit price and no comparable item, as I mentioned before, we calculate a price using justified direct and indirect costs, and we must follow certain rules. Direct cost includes labor costs, construction products and equipment, machinery operating costs, and construction site costs. These are direct costs of construction. And indirect costs we also include, and they cover overheads and profit. When quantities are changed, labor costs for omitted and additional works are limited by the official recommendations. For omitted works, labor costs may not be set lower than indicated in the recommendations. They must be valid at the time of tender submission, of course, because they are omitted works. And related overheads may not be set lower than those in recommendations. For additional works, labor costs must not be set higher than indicated in the recommendations. They must be valid at the time of purchasing the additional works. Related overheads may not be set higher than those in recommendations for additional works. And the recommendations are used as a minimum for omitted works and a maximum for additional works. Here you can see a long text, but I left the original methodology text, so you have the exact wording if needed. Here are prices for construction products and equipment. For omitted works, the price of products and equipment is first calculated using the recommendations. The ratio between the contractor's tender price and the calculated construction cost based on the recommendations is applied. And the construction costs of recommendations are calculated at the time of tender submission. Then this ratio is multiplied by the product price from the recommendation valid at tender submission. If a price cannot be determined from the recommendations, an average market price is used. This is set on the basis of at least 3 other suppliers' prices available at the time of tender submission. If other suppliers' prices can only be obtained in real time, well, it's possible there are no historical data, the price may be based on the current average market price. In that case, the price change from the tender deadline to the moment of omission is assessed using national statistical data. We refer to national statistical data, which were mentioned before, and is available publicly. For additional works, the price of products and equipment may not exceed the contractor's actual acquisition costs. And it is set by applying the same ratio between the tender price and the calculated construction costs. In this case, recommendation prices valid at the time of purchasing the additional works are used. If the recommendation still cannot be used, the price may not be higher than average market price calculated from at least 3 other suppliers' prices. And overheads are not included in the contractor's actual acquisition cost for products and equipment. The same logic is used both for construction products and equipment and for machinery operation. The object is different. In both cases, the recommendations are applied first. If a price cannot be determined from the recommendations, an average market price is used based on at least 3 suppliers, as I mentioned before. Of course, if they are available, if they are acting in certain market, if there are sufficient number of suppliers. And for additional works, the price must not exceed the contractor's actual costs and may not be higher than the average market price. And as with the construction products, overheads are not included in the contractor's actual costs. Site costs, when talking about site costs, they are also subject to clear limits. For omitted works, site costs may not be set lower than provided in the recommendations. For additional works, site costs may not be set higher than provided in the recommendations. While talking about indirect costs consisting of overheads and profits are also calculated according to recommendations. For omitted works, overheads may not be set below the level in the recommendations valid at the tender submission. And for additional works, overheads may not be set above the level in the recommendations, and they must be valid at the time of purchasing. And for omitted works, profit may not be lower than in the recommendations, and for additional works, profit may not be higher than in the recommendations. And in all cases, it is applicable if the rates are not indicated in the contract. Well, Lithuanian practice is not unique, but is, I think, very structured. It is fully based on EU principles, directives, and case law. Anyway, the system doesn't remove all problems in construction projects, but still it gives us clear framework that helps public buyers, contractors, auditors, and donors have the same understanding. I hope this overview gave you some insightful insights for your own discussions and for further improving your practice. Thank you.
Пані Інга, дякуємо вам за виступ.
Ms. Inga, thank you so much for your presentation. All the materials, including your slide deck, can be downloaded using QR code in the left corner, laptop corner of the screen. Please follow the link in QR code and download all the materials so you don't miss anything You also will be able to watch the recording. Recording will be available in English and Ukrainian on our YouTube page and on our Facebook page. Thank you so much, Ms. Inga, once again. And now we would like to give floor to our next speaker, and I'm happy to introduce Mikhailo Mukhnya, who will tell us about the novelties in the new draft law on public procurement, specifically about procurement of constructions work. The draft law 11,520. Mr. Mikhailo is head of public procurement regulation. It represents public procurement department at the Ministry of Economy, Environment and Agriculture. He has over 8 years of experience in public procurement, including at least 6 years with construction works, 3 years on part of buyers and on part of suppliers. And today, Mr. Mikhailo will present his presentation from perspective of the regulators. So you see different perspectives, different roles, and happy to welcome. Please, Mr. Mikhailo, the floor is yours. Hello, everyone. Dear colleagues, partners, and listeners. First of all, I'm sincerely grateful to representatives of EU4PFM project for supporting our industry and development of procurement legislation. It's extremely important for us because understanding of directives and the correct application alignment of our legislation with EU acquis is crucial but very challenging task. I'm also grateful to Mr. Shergin for his work on the draft law and the Public Procurement Department's team on implementation of new regulatory framework. Before I start, let me also highlight that it doesn't matter how efficient the legislation is, and we can draft the best rules and regulations, but it's important not just to implement them, but to train people on how to apply them. This is crucial and essential in measure to show the efficiency of our procurements. This is the reason why we want to do some introductions, tell you about the next updates we expect for our legislation, train our buyers, train our procurement officers and other persons on what to expect in terms of construction works.
Що б я хотів почати,
So,
що буде дуже важливо у
let me
частині
start with a very important topic, essential for understanding. So, in the new draft law, it's suggested to change some terms and definitions, very common terms and definitions of services and works, because currently services and works are based on definition of the scope, subject matter. So the whole scope of so as Mr. Valeri previously mentioned, the logic of directives is not based on the scope of procurement unlike our legislation, but they are contract-based, contract-driven, result-driven. So if you work with directive, you probably focused on contracts, not on subject matter and scope. And here many buyers may come up with a question. So if services, if the definition of services hasn't changed much, then the definition of works has changed significantly. As Ms. Inga already mentioned, our definition of works will be aligned with the provision of directive, and it won't be focused on a certain scope of works, but on deliverables, on the result of construction, engineering, and installation works, which is shows that our legislation is result-oriented, not process-oriented. And here, in light of European integration, it's very important for us to set a clear definition of procurement contracts for works, products, and services. And here, for supply contract, we follow the previous logic, we just clarifies the scope of public procurement contracts, and as for such as lease, and in a context, it's important to focus on works contract, which where we have three important novel aspects. First of all, we continue our logic about design and execution as part of design and build project. And you see item A. We clearly say that these are the activities related to as listed in Annex 1. In our draft, we suggest to add Annex 1. Well, it will be a long document and will be really difficult to integrate into the text of the law. Here I want to show you how this Annex 1 is going to look like. Here we will have classification codes fully in line with the directive logic, where they identify some scopes of work you will be able to identify during procurements according to your needs. Here I will leave a QR code. If you wish, you may scan the link, download this annex, because it's a pretty long document with a list of activities covered by definition of works. Next is execution or design. So in item A, we talk specifically about certain types of works. Then item B is focused on works in general, because we know that in construction, works are usually done in comprehensive and holistic manner, and this item will regulate procurement of overhaul, repair, reconstruction, and new construction. And here we also have the item 3, item C. It's something new for us, and well, something interesting, and it will probably require some further explanations, clarifications, and implementation. The works will also include creation of any facilities in line with client requirements which have critical influence on the design object. So works will also include those objects, those sites, who will be transferred or handed over to the buyer in the future, and the buyer will have a critical control over it. So another novelty after definition, something you need to pay attention to, is the introduction of new co-funding rules. Very often during procurement process and during works, there is a challenge. If the buyer co-funds a facility, what regulatory framework must be applied here? And here, according to the law, introduces new regulatory framework. If the buyer is subsidized over 50%, and the cost of this construction work without WAT, without VAT, is less than 404,000 euros, then provisions of Public Procurement Law will apply. The purpose is to ensure proper control and transparency in use of public funds. This works include any works like this: construction, installation work, construction of hospital, sport and recreation buildings, and administrative buildings. That's how our legislation allows co-funding and governs and basically answers the questions what kind of framework is supposed to be applied here. In our legislation, we also introduced an interesting concept on mixed scope or procurement scope. Many questions emerge in this regard, and this framework has been definitely missing. So what the client is supposed to do when they are buying works and services or products and services as part of the single scope of procurement. So how it's going to be governed? Some of the new novelties are supposed to establish that it will depend on the item with the highest estimated value. So when you procure works and design services, the works will be used for the estimation purpose. Next slide, please. Another very important novelty suggested as part of this draft law is a
Довгий час у нас цього
com
порядку не
project
було, і
the call for
часто
proposals,
ці
project
закупівлі
competition process.
відбувалися на
Very
морозі,
often,
на
public
складах,
such as this has been
конкретно
something which seemed to be
по своїй суті,
impossible
це
due to
не
lack
є
of proper
процедура
regulation.
закупівлі, це
Actually,
процес
it's not a
технічний
procurement
в
procedure.
контексті
The
технічного
competition
спосіб здійснення
is an
закупівель
additional
і
way to
передбачає
conduct procurements,
застосування
which applies where expected value of services is over 140,000
в
euro.
випадках, яких передбачається законодавством. Треба розуміти, що цей спосіб закупівель
or in other cases envisaged by the legislation. So this could envisage the public procurement agreement, or they could do without this, and there could be some bonuses envisaged or some remuneration for the work done. So there is also the general principle of non-discriminatory conditions, but there could be some situations when such procurement envisages all rights for the objects to be designed, because such copyright can affect the whole project and its outcomes. There is a very interesting thing I'd like to highlight. These are novelties in publishing of the acts for the and certificates for completed construction work, certificates of the cost of completed construction work and expenses. And so there are always some issues with different forms and access it, that it makes more difficult to perform proper control over the work done, to verify the value, the final value. That's why the following shall be published. And the price of the public contract, if it's more than 10 million, then the certificates shall be published. So now it is discussed whether it should be published together with the report, or after the certificates, the acts are signed, because they are signed at different stages. They could be final, intermediate, etc. Here I'd like to highlight the following. There is no direct impact of these changes, but they will affect the market price. So there is the procedure of innovative partnership, competitive dialogue, etc. When it comes to the procedure of innovation partnership, this is a very interesting and procedure that we really need, and we did not have it before. This will allow to procure innovations, including when it comes to the work, and this will allow for efficient procurement. And so, as for the competitive procedure with negotiations, this is analog to a competitive dialogue. Unfortunately, we can't use it in full, so they will need to clarify the proper mechanisms in the rules. So this is for complex procurement. This is not for everyday use. And when it comes to the EU, not all countries use procedures on a daily basis. So because they are not just well suited for simple and usual procurements. So there's a question of human resources, the control over such construction, etc. One more interesting novelty. This is kind of a framework agreement and procurement using a dynamic purchasing system and joint procurement. Procurement using a dynamic purchasing system also envisages the possibility to buy work, and it can be used for fast procurement, and this is how it different from a framework agreement. So there could be constant permanent participants with permanent qualification, and joint procurement is another interesting novelty. So the customers will be able to aggregate their needs for one joint procurement with one agreement and with the proper description of the joint needs. One more interesting novelty is engagement of subcontractors or co-contractors. The public procurement legislation only states that there is the right of a contractor to involve subcontractors to execute a procurement agreement. But in the new legislation, everything will be clearly regulated, like the customer general contractor relations or general contractor subcontractor relations. So because sometimes these provisions can be unclear in a contract, and now it will encompass the provisions in the civil code with the additional conditions, as you can see now on the slide. And here I would like to focus on the following. A customer will be able to define all subcontractors in agreement or co-contractors. And one more important novelty that will have an important impact on our procurement. This is the declaration of the share to which a subcontractor is involved. And now customers can require for the share that shall be performed only by a general contractor. And in cases when the share of a general contractor is important for a customer or a contracting agency. So we used to have cases when a subcontractor or co-contractor could perform 99% of work. Now the situation will be different. The next one is division of procurement into lots. The current legislation regulates the division of procurement into lots when one participant can become a winner in all lots. And this is quite difficult and complex issue. First of all, innovations which are offered is that now a customer is obliged to justify it for the decision to refuse to divide the procurement into lots into the documentation. So now it means that the information shall be provided to justify such a decision. And one more novelty, which is very important and will be rather interesting for the procurement, is the customer's right to limit the number of lots for which a contract is concluded with one participant. There could be specific procedures. These novelties are aimed at boosting competitiveness during procurement process, because the proper division into lots just is an incentive for SMEs to participate in the procedure. Not in the cases when one company can win all lots. No, if we define everything properly, this will allow SMEs to participate, and this will allow you to not only select better companies, but also to improve the quality of your procurement process. So this is not about one procurement. So you, as contracting agencies, will be able to assess the market to achieve better efficiency.
Для багатьох замовників буде цікавий, а особливо для учасників
For
змістити
many
забезпечення виконання договорів.
contracting agencies, it will be interesting to learn about the changes in ensuring contract performances. So the legislation envisages the law threshold up to 5%. The new draft law offers to increase the threshold up to 10% because there are issues of failure to fulfill obligations by contractors under the work contract, and 5% is not enough to stimulate them to perform their work. That's why it is offered to increase it up to 10. But there are some conditions. There is the form defined for a guarantee. This could be a bank guarantee or a guarantee of a financial institution or insurance organizations. Quite often, contracting agencies they entrusted some activities to other parties that make it difficult for a wider involvement of participants in the procedure. And one more condition here is the customer is prohibited from demanding cash coverage of the guarantee. The security for the performance of the contract for the performance of work exceeds 5%, just to avoid additional burden on the companies, which can also narrow down the possible number of participants in the procedure.
Загалом, про ці нововведення, які я розповів, це не є
Generally, the novelties that I've covered
загалом
today
коло нововведень буде набагато більше. І воно буде стосуватися
are
як
not all of
виконання
them which are
договорів,
offered. We will have even more changes covering the execution of contract that will provide for more possibilities, and there are always disputes about the decree 668.
Це є набагато більш ширший комплекс, який
So there will be many more actually changes, and we will provide information gradually to you for you to understand the next steps better, for you to get ready, and for you to be able to ask for additional information if it is needed. I'd like to say that before this webinar, we got some questions, in particular, a question about what annexes shall be published in the format, in the machine reading format. And when we were developing these amendments to the law, we had meetings to discuss these novelties with our legislators, and so they have the following logics. So this is for the publication of resources and data. So this is the document containing information about all material resources, but actually the legislation can be amendment, documents can be a change that could affect the execution. But in a contract price, the contract price is not only about the price, for example, for resources, because this information can be found in local estimates and other documents. So there is some inconsistency in the legislation. That's why I would offer you to publish all information in a machine-readable format. This will not be a violation, and you can be sure that you meet the requirements of the law. A contracting agency should not be afraid of publishing this information, because this can only enhance trust, in particular at the construction market, demonstrating that we are open and that everything is fulfilled according to the legislation. Mihaila, thank you very much for answering questions of the participants who have already registered and who could ask questions before the start of the webinar, and both Inga and Mihaila will be able to answer the questions. So our next speaker is Alexander Shatkovsky. I would like to give him floor to cover the specifics of public procurement. And Alexander is the senior legal expert of the EU4PFM project. And for 14 years, he has been working in the area of public procurement, helping to align the Ukrainian legislation with the EU acquis. In his today's presentation, he will be focused more on the topic of design and build, and will also cover some Euro integration issues. Alexander, the floor is yours.
Доброго дня.
Good
Я
afternoon.
сподіваюся, що мене
I
добре
hope
чути.
that you can hear me well.
Отже, ми
Well
розглянемо
done.
питання, чому актуальне
So,
і як
let
краще
us
підійти, і як краще
dive
спробувати
into
реалізувати
the issue
проектуй і будуй, цей
of
механізм
design and
цього
build projects, of how to better implement this mechanism, this format. And let us start with discussing why this issue is important. Perhaps you know that in summer this year, after we had got the new cabinet of ministers, one of the priority announced was that the government wants to have an experiment to use this design and build approach to expedite the recovery of the social and residential infrastructure in Ukraine. This pilot project is envisaged for 2 years. This will be combined with the e-recovery program, and then this idea was formalized and including in the governmental program. And actually, for the wider usage of this format was seen in 2022 with the full-scale invasion. And it was accompanied by the launching of the mechanism, which is called the typical reuse project. I'll cover this a bit later. And in November 2025, so just recently, the new resolution of the Cabinet of Ministers was adopted and envisages a separate experiment as a part of the wider pilot project. The design of and build project for the defense sector, and this is the resolution of the Cabinet of Ministers of Ukraine 1494 of 19th November. Let us generally look into design and build project and what we can see in different sources of international law and our national legislation. In the wider sense, the design and build consists of the preparation of a construction project and the actual implementation of the construction work by a single contractor who will be responsible both for the design and the execution. In this context, there was the government's official communication saying that this approach is one of the innovative elements to update the logics of the construction process in Ukraine, that there will be tenders not only for a design, but also for the turnkey projects. meaning design and build, and the communication also says that such design and build approach is actively used in the EU countries and has proven itself to be an effective mechanism, and it is also emphasized that contractors will be fully responsible for both the development of project documentation and the execution of construction work. If we take a deeper look at universal features of design and build mechanism, then we have several international respected sources. And let us start with the international partners of Ukraine, the European Investment Bank, EBRD, and following the assessment of their documents, following the assessment of the procurement using the loans from these organizations, we can say that such format is more feasible for the new construction and mainly for infrastructure, utilities, transport, social. And when the implemented, designed, and built project will be managed by the same contractor, and this is the so-called designed, build, operate right. This format is also convenient for the construction of new industrial facilities. Then the second feature is the qualifications and management of the capabilities of the project owner. Sometimes when contracting agency feels that the project is rather difficult, there is the practice to engage a consulting engineer from the very beginning of the project implementation, so before even the design is developed. And such consulting engineers support this complex project till the very end of its execution. So, and design and build project envisages that this is more about two-level procedure for the procurement and the complex agreement that encompasses both design and building.
Let's talk about some risks and benefits, characteristics for classic procurements, and for this approach, let's pay attention to the following points. In the conventional procurements of work, the buyer has better understanding of their needs, and because they prepare separate tender and separate contract for development of design documents, and then when they have designs and estimates, they conduct another tender for construction works. So the buyer is more involved, has better understanding of their needs and what's going on. It's also very good material for comparison because in ProZorro system there are many tenders for design and even more tenders for construction work. So you can always rely on experience of other people, compare documents, and requirements for participation in tenders and results. And buyers also have more high level of control. Well, they already have their own designs and estimates, so they are more proactive and better understand how to build communication with the contractor. On the other hand, if we talk about benefits of design and build, well, we expect that it's going to be a much faster procedure because you don't need to follow the sequence, but you can simultaneously plan construction and operation of your project, so you can plan the works back at the design stage. Also, there are high hopes that one tender instead of two will save significant time since these are usually long-term procedures, and also potentially one contractor can be easier to handle for buyer because you have one contractor, you have one counterparty responsible for the entire process. So here we can try to imagine the entire cost of, we can try to estimate the entire cost of project even before we start developing designs and estimates. And if we talk about risks, the traditional procurement process, in addition to classic risks, related to typical for any procurement. Well, if we talk about construction work specifically, it's very demanding because the buyer need at least 2 tenders for designs and for construction, and it creates a higher burden for buyer because buyer needs to interact with designers, with design supervision, with expert evaluations. So basically, the higher burdens. And if we talk about risks characteristic for design and build, here the situation is a bit different. Here, the client has delegated almost everything to a single contractor, but it's also a source of risk because buyers become severely dependent on this contractor who's simultaneously designer and who's will be responsible for design supervision. So the contractor must be really capable and sure in order to ensure fair balance of interests. So this design and build are a bit artificial projects. There are also few of them. And so it's a bit challenging to find other documents, tenders, and procurements for comparison. It's challenging only because since there are only few projects of this type. Now, getting back to international practice and international sources of information on this format, well, of course, we cannot forget organization of the FIDIC, well-known organization of construction engineers and consultants, and they have 2 documents who describe design and build procedure. First, it's classic conventional design and build, a 2-tier procedure with a contract. We have a link on the slide, and please feel free to download my slide deck by scanning the QR code showed at during the opening of the event. In this link, you will find the detailed description and practical aspects to this approach. And there is also a more sophisticated procedure design, build, and manage, which is based on public-private partnership mechanism, because design, build, and manage procedure means that the partner selected on a competitive basis will not just act as a designer and contractor, but also will be a co-investor to subsequently operate and manage newly constructed facility for doing business in a partnership with a public actor. So, now if we take a look at the practice of EBRD and the regulatory framework, there is no special document to govern the design and build procurement. So EBRD does not have it, but if we take a look at project announcements of projects funded by EBRD and published on the EBRD website, we will clearly see that the dominating procurement procedure is a two-stage process for expensive project. Here in the slide, you see example of expensive project where radioactive waste processing plant, recycling plant is being constructed. But if we talk about typical repeated use projects, which are already available as a blueprint, and you can simply apply it to your site, to your locations, and the cost is relatively small. Open tender is sometimes used. Here on the slide, we see example with the solar panel station construction. These solar panel stations are already very popular and standardized all across the world. Now, getting back to EBRD regulatory framework in 2024. corresponding document, procurement guideline, was updated. And in this document, similar to previous revision, there is a separate chapter on design and build, chapter 11 in Annex 1, and it contains the following recommendations. This format is comfortable for sophisticated, comprehensive, and expensive works. It's recommended to conduct procurement in 2 stages using so-called 2 envelopes, quote-unquote. So technical and qualification proposal, price for commercial proposal, and it's highly recommended to use a technical dialogue, so pre-tender market consultations, the term used in our legislation, so the buyer can build a dialogue with market and better understand what do they expect to receive as a result of the procurement. And from procedural point of view, the regulatory framework of the European investment banks can be based on the preliminary qualification and on the competitive dialogue, especially when initial requirements are rather vague and abstract, and there is a need to clarify the requirements to the scope of procurement and tender specifications in general. So these processes and procedures and process are based on EU Directive 24/2014. These procedures are also reflected in our legislation in the loan public procurements, also aligned with this directive. Now let's get back to Ukraine. And let's see how design and build procurements are regulated in Ukraine. Ukraine has a very limited practice of using this format, but still, we have a clear legal ability to use this approach. It was introduced in 2021 when amendments were made to the effective loan public procurement, expanding the definition of work. So now we have another category of works, which are called construction of facilities simultaneously with design documentation development. We remember that in line with the urban planning law, the construction includes new construction, reconstruction, restoration, and major overhaul of the construction site. In order to review the practice of using this approach in ProZorro system since let's say between 2020 and 2025, the most popular classification code is 45/2000. These are works related to construction in complete and incomplete construction objects, but for a number of different reasons, now the only tender procedure available for us is open tender. And before the martial law, the open tender procedure also had been the most popular for a very few number of cases where procurements were done based on this design and build principle. Now let's take a look at some procedures available in our national legislation that are suitable and appropriate from perspective of design and build procurement. First of all, this is competitive dialogue. You've probably already seen that in line with international practice, this procedure is most often associated and the rationale behind it is pretty feasible. Why? Because during the first stage, we keep flexibility to use various options, various design solutions. We can discuss them through negotiation procedure. And here, everything is clearly in line with Item 2, Part 2, Article 32 of the Law of Ukraine on Public Procurement as a grounds for application of competitive dialogue due to the lack of design and the need to conduct negotiations. So during this first stage, competitive dialogue is the only competitive procedure which allows negotiating to clarify procurement parameters, develop the optimal technical, qualitative, and other characteristics of the scope of procurement. Here we have two important aspects. There is a duty to, well, first of all, we need to amend technical part of this first stage, and the client buyers may also introduce changes based on negotiations. And for second stage, we're supposed to invite at least 3 participants based on the stage 1. There is another procedure which usually conducted in 2 stages. It's a limited participation tender, and it can be also used for design and build. And here it's important to understand the difference between it and competitive dialogue. These are 2-stage procedures, but this limited participation tender can be used for any task of procurement, provided that the value is above so-called European threshold, while then build does not depend on works, but can be applied only to works and services. So tenders with limited participation always require qualification screening, so preliminary qualification based on all 4 qualification criteria in line with Article 16 of the law. In competitive negotiations are a mandatory element of the first stage, whereas in competitive bidding and negotiation are prohibited as an open tender. So there is also a difference in deadlines for submitting proposals for the second stage, at least 15 days for competitive dialogue and at least 25 days for restricted tendering. And another important difference, competitive dialogue is still the only procurement procedure which enables buyers to independently define the weight of a price, so they may have any right at the discretion of customers, where several criteria, multiple criteria are used. Whereas in open tender, if a client is using as a criteria in addition to price, the price cannot yet have less than 70% of weight. There is another important point. Since the scope of procurement must be clearly defined, similarly to open bidding, and if the customer applies tenders with limited participation for design and build format, it's very desirable to have well-defined procurement input parameters. So pre-project, pre-design terms of reference, and to organize high-quality competitive tender. We also remember that the cost of entire project must exceed 5 million euros, so-called Euro threshold, and there is emphasis on mandatory pre-qualification selection in order to choose the winner with a more guaranteed best of the best approach. So as of today, this procedure is promising, but temporarily not available, because it's not yet fully implemented in Prozoro and in the capabilities of Prozoro system. So we hope that in the nearest future it will become accessible, but I will get back to it. And of course, open bidding. We cannot forget about open bidding, the only competitive procurement procedure by now. And actually, it looks quite exotic for design and build approach, especially during the martial law, because it's pretty quick. Of course, currently we have the electronic auctions and price as a single criteria dominate in this area, but for this sophisticated, comprehensive, expensive works requiring many years, these conditions are obviously subpar to ensure proper implementation. Also, as I already mentioned, for tenders with limited participation, for open bidding, it's still very important to have as much input as possible. This pre-designed terms of reference with as much data for high-quality project design as possible, and of course, development of realistic expected value. It's directly related to our input. So, of course, it's going to be a very approximate indicative price. We remember that the price is supposed to be published, so we also should be mindful of it. In general, for open bidding and for tenders with participation, it's important to properly design this input. And we have the law on urban planning, which requires us to ensure urban planning conditions, limitations, and plan for the features. At the same time, details of this process are regulated by the order of the Ministry of Regional Development, number 453, dated 2012, and we also have national construction standards towards the scope and content of design requirements, which sets the key criteria for such pre-designed terms of reference for the use for development of designs and estimates. Of course, it's a promise. Design and build is a promising format, but we also need to honestly account for challenges and risks to make the most appropriate decision. Yes, indeed, this format enables us to save time if we organize and plan everything correctly.
And there could be unexpected delays at different stages, at the development of estimates, expertise, and also for the construction, there are always possible some unexpected situations. So that's why this issue is open. The second issue is the quality of pre-project data and also the quality of the agreement, because agreement will cover design and building. So there are two projects, but a lot of elements that shall be taken into consideration when preparing such a procurement agreement. The next issue is IPR. So the construction, the contractor can do everything on their own or involve a third party, but it is very important that these documents can be easily used in the future for some improvements, repairs, reconstruction, etc. That's why it is very important to settle all types of intellectual property rights here, like material, etc. And the fourth element here is the supervision that should be carried out by a contractor who wins the tender. So there should be really professional engineers, consultants that can help a contracting agency just to balance everything. And now let's get to recommendations for the application of this design and build format. So this is a promising format, but you should take into consideration the following practical issues. Both in international and in domestic practice, this format shall be focused on new construction and as a pilot project, it is possible to start from the infrastructure facilities. And here we come back to a reuse project. It's great that we have them and we have the number is increasing. On the 14th of October 2022, the resolution of the Cabinet of Ministers 1160 defined the procedure for such projects, and the portal of the Unified State Electronic System contains the existing list of such typical projects. There are typical models included for the construction of several types of schools, nurseries. If I'm not mistaken, there is a project for a lab, and this database is constantly expanding. And a contracting agency should always think in details about what way to select. There are two possible options, either classic public procurement, tender procedure in line with the procurement law, or the format of design, build, operate. And here we will have public-private partnership format, which can be beneficial because this envisages the possibility to significantly lower public funds. But a project shall be also interested for a private partner, to be able to earn there. And on the 31st of October, we saw the new version of the PPP law, concession law, and so the regulatory framework is being developed. This area is very promising and is rather popular in the EU member states. And the third recommendation is the high level of qualifications for customer, for a contracting agency. This envisages training, advanced training for professionals, and external stakeholders or parties can be involved, like professional engineers and consultants. And by the way, we can see the increasing number of such professionals that can be involved. Recommendations at the procurement stage. Yes, it seems that the competitive dialogue procedure can be more effective here. We've discussed why, but in any case, a contracting agency shall prepare the terms of reference and also to announce the tender for the pre-project task. And it is also recommended to have pre-tender market consultations, perhaps several rounds, both for design and build project and also for technical supervision, consulting engineer, consultant, that will help to have a different perspective on the design and build project task. As for the draft contract, it is of course important. It shall envisage all possible chronology of events, perhaps the situations to revise prices for the cost components, to regulate IPR, and also to define the control function when it comes, for example, to substitution of materials, etc. It is also very important. As for organizational and legal recommendations, there are some obvious steps here. So, if we use the recommended competitive dialogue procedure for this module, then it should be actually be possible to use it because Resolution A1178 does not provide for such a possibility. So the resolution shall be amended first. We can't do without it. To resume the possibility to apply competitive dialogue procedures as envisaged by the Public Procurement Law. It is already there in ProZorro system, so we just need to amend the resolution to apply this possibility. The second recommendation is related to the limited participation tender procedure. Here, we need to finalize the introduction of this procedure in ProZorro.
Має сприяти прийняття нової редакції закону про публічні закупівлі.
And the amended Public Procurement Law can help here.
Досить популярна теж фактично.
This is a rather popular procedure in the EU member states after open bidding. That's why it is very important to introduce this in the ProZorro. And if there is a great interest to this mechanism, perhaps we should think about developing some guidelines about model contract for the procurement for the design build format, the tender recommendations, and actually we have the methodological recommendations approved by the Ministry of Economy in 2024 about the construction procurement. These recommendations are rather efficient, but we should also think how to improve this, and we can think about such possibilities here. That's all from my side. Thank you. And I know that there was a question, Ludmila, right? So I think there are some issues with your video. We can't see your face, actually. There was a question, just a moment.
Про досвід Європейського Союзу запитували.
About the experience of the European Union. What should be implemented in Ukraine in the nearest future? Thank you very much for this question. I've already seen it, actually. So there are several issues. First thing is that a lot is being implemented when it comes to the construction. Like resolution of 2022, the model projects for reuse. This is a great practice, and actually this is an international practice. And we can see that consulting engineers are becoming more popular. This is a great response to the challenges of our time, because we can see the increasing variety of different type of work, in particular because of the war. And there are a lot of technologies, modern technologies, like using 3D printers for construction, and a lot of technologies to process construction waste and some other residues or some ruined places or facilities. So this is a rather popular practice. And we will be able to achieve significant progress after the Public Procurement Law is amended, because this reflects this will reflect the EU practices, like expanding the framework agreements. This will be the continuation of the existing mechanism. And this is also, of course, the part of our accession path. And for example, this design and build tool can be used, but of course we should be conscious of this, and this will also reflect the best EU practices. So thank you. I would like to thank our speakers. I would like to thank Inga, Alexander, Mikhailo. I would also like to thank our participants that were rather active on our Facebook page and in our YouTube channel. And thank you very much for introducing yourself. We know more now about you. Thank you for such feedback. And perhaps Our speakers would like to add information here, or if they have some comments or remarks, will gladly give them floor. And I would like to highlight that we've got a lot of questions during registration, and in their presentations, speakers were able to provide answers to most of the questions. There were some questions about Resolution 1512, and the Ministry published yesterday the information to clarify this resolution. Hopefully, this information will be useful for you. There is also additional information about construction work published on the information resources of the ministry, and this information can also be useful. And perhaps Inga now would like to add something, or Mihaila has some comments, remarks, or additional information. So if our speakers would like to add something to wrap up our webinar, I can give floor to them, and then we will give floor to Valeria Shargin. Inga, the floor is yours.
Дякую, Людмила. Well, it seems that Ukraine procurement law is becoming closer to the European Union public procurement directives. And I see that among all other benefits, this will help suppliers to better understand that procurement we are running here in Lithuania for Ukraine, for even especially for construction procurements in Ukraine. I think it should also make it easier for Ukrainian suppliers to participate in procurements in even other European member states, because it's sometimes difficult for them to understand our rules. So if we'll have the same, it will be easier for all of us. Maybe I could add some thoughts for consideration about splitting procurement into lots. We are doing this because smaller suppliers can participate. And this principle in EU is called divide or explain. It means that procurement by the default should be divided into lots. Only then if there is some genuine, not formal justification, it is acceptable not to do so. The same approach applies to design and build contracts, and this principle is more commonly used for buildings that generally do not require particularly distinctive, some particular architectural solutions. For example, we executed design project for the adaptive reuse design, and it included innovative approach, and we called it not just reuse design, but not just typical design, but adaptive. And well, we already have this adaptive design going to an end. We're expertising it and planning the new procurement for preparation of, we're preparing for localization of such project. But we rejected the idea to execute design and build contract, as we need our design to be more adaptive, and we need designers which are very strong, which would include community in Zhytomyr, where we are going to build the first school according to this reuse design. Therefore, we need strong designers, not dependent from the contractor, and the main idea to be implemented. So I think it's just an example for you to consider in this area. Thank you.
Thank you, Inga. Дякуємо дуже, пані Інга. Пане Валерію, вам
Thank you very
завершальне
much,
слово.
Inga. And now I would like to give floor to Valeria Shargin for the final word.
Добрий день ще раз.
would like to welcome everyone once again. I think that this webinar was really very successful. The topic is very interesting. I would like to thank Inga for this. Thank you for sharing your experience.
Багато що, як ми побачили, для України, для українських
We
замовників не зовсім звично.
can see a lot of new things which are unusual for Ukrainian contracting agency. I would also like to thank Mihailo for sharing information about Draft Law 11,520. I would also like to thank Alexander for presenting this design and build model, because I believe that this is rather promising tool, in particular for Ukraine, taking into consideration that we will need to reconstruct a lot of facilities, actually in a short period of time. And actually, I'm going to say that today is the day of land troops of Ukraine, and perhaps some of the participants of this webinar are actually parts of these units, and I know that there are people whose family members serve, and I would like to actually welcome everyone on this holiday. And actually, I would like to say that we are thankful to the armed forces of Ukraine, and I hope that in the future we will be able to think not about fortification, but also about the construction of school, actually hospitals, etc. Thank you very much for this webinar, and have a nice